Wonderful. Well, I'll probably go ahead and present, and I'll try and leave at least 5 or 10 minutes at the end for any questions that
That's
come
right.
up.
That's right. So
And
give
if
about 10 to 15 minutes time for question answers.
okay. Well, I'm delighted to be here and had a wonderful visit to Amity in January, which I remember very, very fondly. And I was so impressed with the professors and the campus, and I was on the Noida campus in the school. So I'm just delighted to be here. My topic today is the Foreign Corrupt Practices Act, which is a law in the US that was passed in 1977 to deter bribery and corruption. And I have a PowerPoint presentation that I'll take you through as I talk with various comments, and I'll leave time at the end. So give me just a second and bring up the PowerPoint here. Hopefully that's visible.
Yes.
And can everyone see that?
Yes, please.
Okay, great. So as I said, the US, it's a US law that we're going to be talking about, the Foreign Corrupt Practices Act. And by the end of the presentation, hopefully you'll be able to answer what it is, what the Foreign Corrupt Practices Act is, who is subject to it, why it's so important. It's been increasingly important in the United States, what the anti-bribery provisions of the Act, and what the exceptions and defenses are of the Act. And the Act is a tool to deter US companies and companies that do business in the United States from bribing foreign officials in other countries to get their business done. And what constitutes a bribe is a very contentious subject. So before we go on, I wanted to just sort of take you through an example. And as I talk about the example, think about, is the actions of this company I'm going to describe, are they okay? Are they moral, immoral? Would you consider what they're doing wrong or a bribe? So let's imagine there is a United States company that's active in Nigeria, a large US company. And what that company wants to do is to set up a processing plant in Nigeria to produce cocoa or chocolate. And it wants the company in Nigeria to be a wholly owned subsidiary. However, Nigerian law prohibits wholly owned subsidiaries by foreign countries. But this company is able to get permission to establish the subsidiary by treating government officials to fancy meals and also making campaign contributions to those government officials. By taking those actions, they're able to get permission to establish the subsidiary. Think about that. Is that action okay? Is that moral or immoral? Just think in general terms. Don't worry about legal terms, but just think in moral terms. Second, imagine that the company has to get permits for its cocoa processing plant. And the only way it can get permits from the government is it agrees to construct employee housing, it agrees to construct recreational facilities, and it agrees to subsidize employee transportation to and from work. Is that okay? Is that immoral or wrong? And answers may vary, but just think about this. Third, imagine that the only way the company can get permission for the raw materials it needs is it has to pay $1,000 on a regular basis to customs officials. And it makes these payments so that the customs officials will expedite the approvals. Normally it takes a year, but by paying $1,000, they can get it done in a week. Is that all right? Is that okay? Finally, when it's time to sell the plant, and it needs the approval of the Nigerian government to sell it, and so what it does, it hires a Nigerian consulting firm and pays them $500,000. And this consulting firm has great contacts with the government. And then the company just records the fee payment as an ordinary promotional expense. So after it gives $500,000 to this third-party firm and says, use whatever contacts you can with the government, it gets approval. Is that payment okay? And what I mean okay is morally okay. And we'll talk whether it's okay under the FCPA in just a minute. These are common barriers and common activities that businesses were engaged in before and maybe even after the FCPA. And what I'll tell you is almost all of them would lead the company to be liable under the FCPA. So let's talk about the FCPA a little bit. So the Foreign Corrupt Practices Act, it's a law that prohibits the bribery of foreign government officials. It has anti-bribery provision and requires companies to maintain accurate books and records. And it's enforced by the United States Department of Justice and the Securities and Exchange Commission. U.S. Congress passed the FCPA in 1977 after U.S. firms in a survey admitted that they had spent over $300 million in bribes in foreign governments to get their business done in foreign countries. What's wrong with bribery? Why should the U.S. care that its companies are bribing foreign officials to get business done? You know, the FCPA is controversial. The current President Trump has been quoted as saying it's a horrible law and the world is laughing at us. When the Secretary of State informed Trump that changing the law would require an act of Congress, Trump complained that it was just so unfair, and I'm quoting, "It's just so unfair that American companies aren't allowed to pay bribes to get business overseas." So the law definitely has critics, but supporters of the law note that the purpose of it, what bribery does is it makes business overseas unstable. It threatens security by facilitating criminal activity, and it impedes economic growth because it diverts public resources from important priorities. And it's just morally wrong on top of that. And those were some of the motivations that led the US government to pass the FCPA. It's been increasingly enforced with a recent judgment of over $4 or $5 billion against Airbus. This was a judgment out in February 2020. Airbus is a French aircraft company, and it agreed to pay over $3.9 billion to the Department of Justice, as well as authorities in France and in the UK, because of bribery it engaged in to solicit purchases of its aircraft. So there are huge fines and payments that are being made pursuant to the enforcement of the Foreign Corrupt Practices Act. Okay, so who's subject to the FCPA? An issuer, so any company, US or foreign, with securities registered in the US or that files reports with the SEC. So if it's a US company, it's subject to the FCPA, or if it's a foreign company, trades stock on the New York Stock Exchange or is registered with the Securities and Exchange Commission, it's going to be subject to the FCPA. Also, US citizens are subject to the FCPA, any US entity organized under US law, and directors, officers, employees, agents, and shareholders of those companies. And just so you know, the Department of Justice has interpreted these categories very, very broadly to encompass companies both inside and outside the United States. Also subject to the FCPA is any individual who commits a violation through any contact with the US. So if you make a phone call in or to the US Department of Justice may try and impose FCPA violations on you. If you send an email that's routed or stored through a US server, you may be subject to the FCPA. Or if you send a wire transfer to or from a US bank, or you travel to or from the US. So enforcement under the FCPA is very broad. If your company is subject to an FCPA enforcement action, it can be expensive and long investigations, criminal fines, civil penalties, and potential imprisonment. Walmart was subject to a large enforcement action under the FCPA. Walmart's the largest employer in the United States, and spent $500 million just in legal fees to defend against the FCPA enforcement action. In 2010, let me just note, the Security and Exchange Commission's Enforcement Division created a specialized unit to enhance its enforcement of the FCPA. And the FCPA has more resources today than any time before, including FBI agents, attorneys, paralegals, and it's working with every major U.S. attorney's office in the United States on FCPA matters. In 2015, the FBI established 3 dedicated international corruption squads just to enforce the FCPA. So, as I was mentioning, these increased enforcement trends. In addition to the information on the slide, let me just note, in 2018, the Department of Justice and Securities and Exchange Commission collected or obtained agreements exceeding $2.8 billion in fine. In 2017, it was 1.9 billion. In 2016, it was 2.4 billion. So there's been very aggressive enforcement of corporations and of individuals regarding to the FCPA. So more information. So companies can face a $2 million criminal fine for violation. Debarment, meaning the company can't do business. Denial of export license, disgorgement of profits. And then individuals can suffer up to 5 years in prison for violation. You see the various fines, loss of job, reputational damage. No matter, let me mention though, no matter where in the world you're doing business, there's likely going to be some type of anti-bribery law that applies. So India has the Prevention of Corruption Act, which I did a little bit of research, and many of you know much more than I about that Prevention of Corruption Act, but I noted that it was recently updated in 2018. There's other US laws besides the FCPA that go to combat bribery. There's the General Federal Bribery Statute, some anti-money laundering statutes, and antitrust laws. So let's delve into a little more detail about the anti-bribery provisions of the FCPA. The FCPA prohibits current corrupt payments or bribes. And here's how a corrupt payment is defined. And think about that Nigerian example that we gave earlier. It's the gift or offer or promise or authorization to give anything of value to a foreign official to obtain, retain, or direct business. That's how a bribe is defined. It can be made directly or indirectly with knowledge that the payments will be made to the foreign official. Now, the bribe can take many forms. It's not just a payment of cash. And there is no minimum threshold for what the expense can be. There's no minimum amount in terms of the bribe. So let's again break these down further. What's a gift or offer, a promise or authorization to give? A company and its employees can be liable for bribes that are made, offers, promises, or attempts to bribe, or authorizations of bribes made by others. And that can be anything: cash, gift cards, stocks, gifts, travel, meal, lodging, entertainment, personal favors, discounts, loans, donations to an official's charity, political contributions, like we talked about in the example. Even the smallest bribes are prohibited under the FCPA. So here's an example regarding gifts and entertainment. So I'll just summarize the slide here. So the foreign subsidiaries of a U.S. manufacturer of bank security systems spent $1.8 million on pleasure trips for senior officials of government-owned banks to places like Disneyland, Paris. Its subsidiaries also provided government bank officials with annual cash gifts ranging from less than $100 to more than $300. That's bribery. That travel, entertainment, and other perks meant to influence these foreign banks' purchasing decisions counted as bribery. And that company ended up paying over $48 million in fines for FCPA violations as a result of these gifts. Let's take another example: charitable contributions. So a U.S. pharmaceutical company had a Polish subsidiary, and it made $75,000 in charitable contributions to a foundation that restores ancient castles. You may think, what's wrong with that? Castles are wonderful. What's wrong with making charitable contributions? Well, the foundation's president was the director of the health authority, which had the use of healthcare funds. So the Security and Exchange Commission found the contributions were made to influence the foundation's president and found the company liable and imposed a $500,000 civil penalty. Let me just take a little bit of a side. Many companies like the FCPA because it levels the playing field. It provides stability, and companies, if they can feel confident that anti-bribery laws are being enforced, can feel more confident about the business they conduct and that they're being treated fairly amongst their competitors. Precautions that folks and companies should take regarding gifts. Make sure they should be improved in advance by the legal department. They should be of modest value. A calendar, a pen, a mouse pad, or a book, for example. Responsible and appropriate to the occasion. The Department of Justice has given guidance that a smaller expense is in general going to be much safer than a larger expense, because if you give a gift of nominal value, it's not likely to influence a foreign official. However, even if you give small items, a pen, a mouse pad, or a book, if you have a corrupt intent, that can violate the FCPA. So here, if it's just a token of esteem, a small gift, it's fine. Here's some examples of nominal fare of items of nominal value that don't generally violate the FCPA. Cab fare, reasonable meals. Large and extravagant gifts are inappropriate. So sports cars, all inappropriate. If there's trips that companies pay to tourist attractions or trips that aren't directly related to the business, that can run afoul of the FCPA. If a company is treating friends, spouses, or other family members to various gifts or trips or meals, that can also be a violation. If a U.S. company or a company registered in the U.S. with the SEC is going to be treating foreign officials to travel, it should be directly related to promoting the company's products of a reasonable amount, and the fund should be directly paid to the travel vendor rather than reimbursing the government official. And you'll see the reimbursement should equal the actual expense. So these are good rules for a company to follow. And many of you may be counseling a company at some point. And if they're at all possibly subject to the FCPA, this is the counsel that I'd recommend you give. Meals and entertainment should be modest, appropriate, and customary. They shouldn't be provided regularly or frequently to the same official or group. They should be tasteful, and you should have a representative of the company present. You shouldn't just provide meals for foreign officials off on their own. All gifts, travel, and meals should comply with local law, be accurately reflected in the company's books, and not be offered at the request or suggestion of the government official. So, for example, if you provided a government official with a modest dinner while negotiating a business contract, that might be okay. That might be okay. Okay, what is a foreign official? The FCPA defines a foreign official very broadly. So it includes anyone acting in an official capacity on behalf of a foreign government, a department agency, a public international organization, a foreign political party, or political office. A doctor at a state-owned hospital can count as a foreign official. If it's a government-owned company, employees of that government-owned company can count as foreign officials. And it doesn't matter if they're low-ranking or high-ranking officials. Members of royal family are certainly foreign officials. Here we cover this first one: employees of state-owned or state-controlled enterprises, banks, hospitals, schools. Close family members of a foreign official can also be considered foreign officials for purposes of the FCPA. Okay, the next element: obtaining, retaining, or directing business. Before we go on to that, let me go back here in just a second. Sometimes a company subject to the FCPA will want to be doing business in a country where a lot of the economy is owned by the state, such as China or Russia. And there, the company has to be especially vigilant because ownership of the economy and of businesses is so widespread by the foreign country. Okay, obtaining, retaining, or directing business. This is often called the business purpose test. And so to be a violation, the payment has to be made corruptly with the intent of inducing a foreign official to misuse his official position or take an action or to make a decision that would benefit the business interest. And intent can be found if there's just willful ignorance. You can't escape the intent requirement by hiring a third-party consultant and saying, I didn't know what they were going to do to obtain the contract or obtain the approval and obtain the permits. They just mentioned they had connections. That willful ignorance is also considered intent, acting with intent under the FCPA. Here's some examples of obtaining and retaining or directing business. So if you bribe an official to get favorable tax treatment, or reducing or eliminating customs duties, or influencing the rulings in lawsuits or enforcement actions, obtaining objections to regulations, all of these count as efforts to obtain, retain, or direct business. A case involving an Indian company recently called InBev, Anheuser-Busch InBev. There were bribes made to low-level Indian officials to extend the working hours of the plant, so that the beer plant, so that the workers could work longer hours. That fell afoul of the FCPA. Can be made directly or indirectly. So if there's corrupt payments made directly by the company, made by their employees, or made by third-party agents. And this is where a lot of enforcement comes in, because a company may not always know what its third-party agents or subsidiaries are up to. It doesn't matter. The company is going to be liable for the actions of the third party. Even if they acquire the third party, they can be liable for actions of that third party that occurred prior to the acquisition under the FCPA. They inherit the bad actions of the third party. So third parties can include agents. Here you have a list of all the different examples of third parties: sales reps, distributors, accountants, lawyers, consultants, brokers. Anyone acting on behalf of the company can expose the company to liability for bribes or corrupt payments. So let me just give you an example here. There was a U.S. aluminum producer who engaged a consultant who claimed that the consultant had connections. He had connections to obtain business with a government-owned plant in Bahrain. And he used money from his commissions from the company to funnel bribes to the Bahraini officials. The Security and Exchange Commission charged the U.S. company with FCPA violations as the result of the actions of its subsidiary, and found that the U.S. company did not conduct due diligence or seek to determine whether there was legitimate business purpose. So even though the U.S. company was not aware of the actions of its agents, it still has to conduct due diligence and investigations to make sure that its agents are acting properly. And in that particular case, the U.S. company and its subsidiary had to pay $384 million to settle the enforcement action. So ignorance as to what your third-party consultants are up to is not a defense. As I mentioned, third parties present the greatest risk under the FCPA. 85% to 90% of recent FCPA enforcement actions involve corrupt payments made by third parties. So here's another example. So an Argentine subsidiary of a U.S. retailer used a third-party broker to pay bribes. The subsidiary's general manager also bribed Argentine officials with gifts of perfume, dresses, handbags. The subsidiary's general manager was considered the U.S. company's agent, and the U.S. company paid over $1.6 million in fines. It didn't matter that the U.S. company didn't know what its subsidiary was up to. Even if these payments are customary in the country in which the subsidiary is located, it can still subject the U.S. company to FCPA liability. Also, third-party business relationships. So companies are going to be liable for the activities of their co-investors, their partners, their joint venture partners, and acquisition targets. So let me just give you an example here. Here's a French engineering company had a minority interest in a joint venture to bid on contracts in Nigeria. The joint venture used third-party agents to pay over $180 million in bribes to Nigerian government officials for the contracts. Executives of the French company participated in the joint venture committee meetings. The Security and Exchange Commission found the French company liable, and they had to pay $240 million in fines. Here, the U.S. government had jurisdiction over the French company because they were listed on the New York Stock Exchange. That gave them jurisdiction. And even if a company doesn't hold an interest or control the joint venture, it can still be liable for the joint venture's violations if it participates in the bribery or becomes aware of the bribery. Due diligence of third parties. So whenever a company is entering into a relationship with a third party, the company's policy should require a review of the third party's qualifications, public record search, a reference check, a signed agreement by the third party, and review of any red flags. Doing these things will help insulate a company from bad actions by a third party if it goes through this process. So the violation has to be made with knowledge, next element. And knowledge of a corrupt payment means actual knowledge, a firm belief that the corrupt payment is being made, or willful blindness, deliberate ignorance. We've talked about this. Actual knowledge is not necessary for FCPA liability. Here's an example. U.S. investors, foreign business associates bribed Azerbaijan officials to privatize a state-owned oil company. The court agreed the U.S. investor had consciously avoided confirming this corrupt activity and should have been aware. They should have known there's pervasive corruption in Azerbaijan. They should have known about the business associate's reputation for fraud. All of this should have known was a burden on the U.S. company. They should have done an investigation into the third party they're using. Now, I want to move on to exceptions and defenses to FCPA liability. If a company has to make a payment in response to imminent threat of physical harm, then that does not violate the FCPA. So this can occur in high-risk countries where employees may face real threats of violence or harm, and payments made in response to those threats do not violate the FCPA. Mere economic coercion is not extortion. So if, for example, a government official demands payment for a company to gain entry into a market, that doesn't give the company an extortion defense. Okay, next, and this is a very interesting issue, facilitating payments. And facilitating payments are payments made to expedite routine, non-discretionary governmental functions. So if a government's official already has to do something, already has to take an action, like issue a license, paying that official money to speed up the process of issuing the license is not a violation of the FCPA. Grease payments, right? You're greasing the wheels. You're not inducing the government official to do something that they don't already have the duty to do. But by giving the payment, you are causing them or inducing them to do it more quickly. That is may be considered a facilitating payment under the FCPA. Now, as you can imagine, this is a really gray area. At what point is making a payment to expedite a routine function stray into bribery? And notice it has to be a non-discretionary governmental function. So if there's a government official that has to decide whether to grant a permit or not, that's discretionary. Making a payment to sway that governmental official violates the FCPA. But if the government agent is already bound to give the permit, then making the payment to just expedite its issuance is not a violation of the FCPA. So a very interesting exception that's created a lot of litigation. Okay, next, if a payment is expressly permitted under the written law of the foreign country, that can be a defense to the FCPA. So, for example, if an administrator appointed by a foreign court needs to be paid to undertake his or her duties, and that is permissible under the written law of the foreign country, that may be okay. This is called the local law defense. And notice that written laws of foreign countries are not ever really going to permit corrupt payments. So that's what undergirds this defense. Bona fide expense defense. So promoting products or services, executing or performing a contract can be a defense. So, for example, payment of travel or lodging expenses that are legitimately part of promoting the business of the company, traveling to an educational event, providing samples to government officials for testing and evaluation, all falls within this exception. However, luxury and recreational travel would not. But if it's legitimate promotion or provision of products or services, it's okay. It's under the FCPA. Okay, next. Well, here, for example, things that fall out of the bona fide expense defense. So, a U.S. telecom company provided sightseeing trips to heads of state-owned telecom companies in China to win contracts. The sightseeing trips were in Boston, Hawaii, and the Grand Canyon, big vacation spots in the U.S. They did not visit factories or discuss business content. That is not a bona fide business expense. That is bribery, and the U.S. company ended up paying $2.5 million in fines. So now I want to give you a hypothetical here. I have a couple hypotheticals for you, and then some other case examples that we'll talk about. So if you read the slide, ABC Chemical Company is a Delaware company traded on the New York Stock Exchange. ABC enters into agreement with a French company to submit a joint bid to the Ministry of Agriculture in Vietnam to build a chemical plant in Vietnam. ABC and the French company decided to hire a third-party consultant with connections to the ministry. ABC and the French company and the consultant meet in New York and agree that the consultant will use part of his commission to bribe ministry officials. So who is subject to the FCPA? Is ABC subject? Is the French company subject? Is the third-party consultant subject? Who is subject? Just think a minute about what we've gone through and see if you can answer who's subject. All of them are. So ABC is on the stock exchange and is a domestic concern. The consultant is an agent, and the French company and the consultant are subject to the FCPA because they were engaged in conduct in the US. They were in New York in business meetings. Even if they never met in the US, there's still conspiracy laws that would apply. But in that example, all three are subject to the FCPA. Okay, next hypothetical. So Samuel Cellalot, the sales representative of a U.S. medical equipment company, meets Carlos Connection at a trade fair. Samuel's trying to build a market for his company's products in Mexico, especially in public hospitals. Carlos offers to connect Samuel with hospital officials and promises to get his products through customs without a problem. Samuel learns that Carlos is known as someone who, quote, can get anything done in Mexico. Carlos's brother is also a high-ranking official in Mexico's Ministry of Health. Carlos's fees are triple what other agents charge for similar services, but he guarantees success if Samuel hires him. What are the red flags in this scenario? What, if you're counsel for a company subject to the FCPA, what in this scenario should raise objections and concerns in your mind? Carlos is going to be engaged as a U.S. company's agent in Mexico, a country with a reputation for public corruption. the case I mentioned earlier with Walmart, the investigation started in Mexico. Walmart hired a number of folks for modest pay who were known of having connections to various local officials in Mexico to get approval for their stores, and engaged in bribery. So first of all, you've got to be extra careful if you're dealing with a country where has lots of problems with corruption. Next, Carlos is going to be interacting with foreign officials. That's another issue you've got to be really careful about. You really need to get to know Carlos well and really take the steps to make sure Carlos is going to behave. He has a reputation for getting anything done, guaranteeing success. His brother's a foreign official, and his fees are unusually high. Why does he have such high fees? All of these things you would really want to investigate before hiring Carlos on behalf of your company. So here, wanted to give you a sense of, these are FCPA enforcement actions worldwide. Just a summary from 2011 to 2020. You see that here are the location of improper payments. So China, you see, has the most, with 48 investigations. Brazil, then India, Mexico, Russia, Indonesia, Angola. Goes down the list. And I wanted to focus a little bit about FCPA enforcement actions in India, or not in India, but with Indian contacts of companies that are getting charged with FCPA violations while doing business in India. And there would be perhaps a great business as a counselor to advise both U.S. companies and subsidiaries in India regarding how to avoid FCPA enforcement actions. So here are some of the companies involved. Baker Hughes, well, you see the list of the companies: Electronic Data, Dow Chemical, Textron, there are others. Pride, Tyco, Walmart, Beam, this Anheuser-Busch InBev, and then most recently, this Cognizant Technology Solutions. I wanted to mention Cognizant a little bit. It was a very recent. They ended up having to pay a $25 million fine. And what was alleged was that a senior government official in Tamil Nadu demanded a $2 million bribe for the construction firm responsible for building Cognizant's 2.7 million square foot campus in Chennai. It was going to be one of the largest technology campuses in Chennai, and this government official demanded quite a large bribe, which Cognizant provided. Cognizant's president and chief legal officer authorized the bribe. They personally ended up paying more than 1.6 million, and 12 different criminal charges were brought against them for bribery. Wanted to tell you a little bit about the Diageo event, it's probably Diageo. It's a UK alcoholic beverages company. It was headquartered in London. It's registered on the New York Stock Exchange, and thus it's subject to the FCPA. It had an Indian subsidiary, and that subsidiary made to a whole variety, to more than 900 different low-level Indian officials, over $1.7 million in bribes to get all sorts of various favors in relation to the alcohol business, resulting in more than $11 million of extra profit. Diageo ended up disgorging over $16 million. Here are brief summaries of some of the larger FCPA enforcement actions involving Indian subsidiaries or actions in India. So it's a burgeoning area of law in the U.S. It affects not just U.S. companies, but companies and subsidiaries with which U.S. companies do business, or even companies like Infosys or Tata Auto, right? Tata Cars that trade on the New York Stock Exchange can be subject to FCPA enforcement actions. So anyway, so that's
Now,
Sure.
I will start my question first. Then I will
Sure.
give the question to others. My question to you is there no thinner line between high political decision and corruption? For example, I give
Yes.
you that through lobbying, you see, import duty of a particular commodity is being reduced. And through that process, government wanted to help some businessman. And
Right.
indirectly must have got some money, we do not know really. But the way it was projected to the nation, that through that import, lots of facilities will be created for the common citizen. So the thinner line between the bribery and very strong decision. That's the question number one. And then there are other questions also.
It's a difficult question. It's a difficult question. Where does lobbying begin, and when does that become a bribe? And so in the United States, there, people lobbying on behalf of a foreign country have to be registered. They have to disclose who they're representing, what they're being paid. But that said, they're going to try to influence government officials however they can, with whatever influence they can. But that requirement of registration and supposed transparency in who's funding them and who they're representing perhaps makes a little bit of distinction. But it's a difficult question.
Can you say that it's a difference between avoidance and evasion?
It's very difficult. Very difficult. A lot of U.S. companies say, this law makes it difficult for us to do business in other countries, and it actually harms. One argument I saw recently was that it can harm countries that aren't developed, that need foreign investment. So anyway, I'm sorry, but yeah, let's go ahead.
Other questions? There are similar questions. Difference between lobbying and bribery. Giving gifts under lobbying be equated with bribery? This is one question.
Yeah, again, if going back to the small tokens of esteem under the FCPA are fine. When I know that when the president receives very large or beautiful gifts from other diplomatic officials, those go to a museum, or they are not the personal property of the government official or the president. In general, though, any gift to a public official has to be completely of nominal value, nothing more than a token of esteem.
Now, can U.S. government apply FCRA enforcement wings to international entities outside USA?
They can try, and they can bring actions in the U.S. And then, if the entity is listed on the New York Stock Exchange, they can try and evade U.S. enforcement. But the cost of that business and the sanctions that the U.S. government can impose may be greater than submitting themselves to the jurisdiction of the FCPA. So the U.S. government asserts jurisdiction over companies that have even minimal contacts with the U.S. Right? You saw in that one example, the company just had a business meeting in New York. That was sufficient to subject it in the U.S. government's eyes to the FCPA. Now, whether or not the government will be successful in enforcing a judgment, depending on where that country is and what the circumstances are, that's open to question for sure.
Now, can these FCPA terms be violated in terms of property in US?
Sure. So, if I understand so the FCPA is directed at foreign corrupt practices. So it's targeted at bribes to officials who are outside the U.S. There are other laws that prohibit bribery within the U.S. but that's not the FCPA. There's a whole variety of different laws that prohibit bribery of U.S. officials. But the FCPA is just targeted at bribes to foreign officials.
What is your opinion about Walmart case?
Oh, you know, it's very interesting. I listened to it was an archived call-in show on the internet when the Walmart case first broke in 2012, and Walmart can be at times a really controversial company in the United States. They're the largest employer in the U.S., but they tend to, because they're so large and because of their purchasing power and because they try and sell things at the cheapest possible price, they put out of business many local businesses, many local supermarkets, many other markets. And they have a reputation of paying their employees not very much money. So they often are a controversial company. So when you added that with Walmart paying bribes, the investigation started in Mexico. When they were paying bribes to many, they were using third parties to pay bribes to lots of foreign officials. That really upset a lot of people in the US, because not only were they shuttering local businesses by their business activities, but now they were paying bribes to expand even further. And once the activities were uncovered in Mexico, the investigation spread to every other country where Walmart did business. And as I mentioned, just their legal fees, not talking about the fine to which they were eventually subjected, just their legal fees alone were $500 million. So I think the company was much better off for the enforcement action. It really taught them to behave in various jurisdictions in which they exist, and it's a real sign of what the real teeth are behind this act. And even though, as I mentioned, President Trump really dislikes the act and is a big critic of it, the enforcement actions have stayed constant and continue to expand because of the resources that are already in place.
Walmart says that this money is used for the purpose of lobbying.
Well, that I need to learn more about the case, but from my understanding, it wasn't lobbying. It was paying third parties to directly bribe folks to get permits where Walmart otherwise wouldn't have gotten them.
But another very interesting question related to the criminal proceedings: which country has the jurisdiction where there is a criminal proceedings under FCPA? Is there a provision of pecuniary jurisdiction?
So I know in several of these cases, if a company's committing bribery in a variety of countries, the countries involved will work together to jointly prosecute the violator. So you'll have a criminal action in the US, a criminal action in France, a criminal action in India, right? Where the prosecutors cooperate as to if an issue arose about who has proper jurisdiction.
Yes.
That's a tough one. As you can see under the FCPA, the U.S. asserts very broad jurisdiction, and if they meet any of the factors I've described, they're going to try and assert jurisdiction.
True. But again, question is that remains still a gray area. That is the way how I look at it.
I'm sorry. You broke up a little bit.
This area still remains a gray area.
Yeah. Well, for me, the grayest area under the whole FCPA are the facilitation payments. You remember how I described that if an official already has to do something, is already bound and has a duty to do something, to grant a permit, right? If there's no discretion, paying that official money to make him or her do the thing faster,
yes,
is not a violation of the FCPA. That's quite remarkable to me. That's quite remarkable.
But how do they react on the Union Carbide case? We must be well aware of Union Carbide case, the Bhopal
Is
gas
this,
tragedy.
oh, is this the Bhopal case
That's right, absolutely.
back in the 80s?
That's right.
Yeah, I'm
Sometimes it happened, sometimes in late 90s.
yeah, I I'm not aware of how the FCPA might or might not apply to that case. I'm just not familiar with that application.
The number of questions, what will be the effect of non-eradication treaties?
Yeah, it's very
Non-eradication
interesting.
treaties.
It's interesting. Again, let's say you've got a company issue that's on the New York Stock Exchange that doesn't want to comply with some FCPA judgment against it. And let's say there's individuals involved and they, for whatever reason, legally they can't get extradited. The U.S. can still take actions against the company and company assets in whatever business it has in the U.S. So even if there's non-extradition treaties, as a practical matter, the U.S. can bring all sorts of other things to bear on the companies and officials involved.
But another very, very brilliant question by a student. It says that there is a research is done in employing, so many research have been done in employing the agent. There seems no problem, and in future the agent work in his personal capacity, then the company will be finding violation under FCPA.
Yeah. So tell me that again. So the let's say the company really investigates the agent.
A company employing the agent, there seems no problem, and in future the agent work in his personal capacity. The company will find find violation under FCPA if he works in his personal capacity. The Brazil case.
That's a great question. So here's how the company can insulate itself. It can do before hiring the agent, it can do a due diligence investigation of the agent, the reputation of the agent's contacts, of the agent's activities. It can check in with the agent regularly to get an update on what the agent is up to. There's also, I didn't mention it in the presentation, but there's benefits for self-reporting. So if a company discovers an agent or its employees have acted in a way that potentially violates the FCPA, if they report that activity to the Department of Justice or the Securities and Exchange Commission, they can avoid liability. This was a pilot program that was put in place in 2016, which said, hey, companies, if you report potential violations and you're upfront and investigate, we will nearly eliminate your liability. So that's I guess my answer to that question. Even if you have an agent that goes rogue or goes bad, if the company's taken that steps, they can really decrease potential liability.
So another, of course, now time is coming to an end. But although there is another interesting questions, the question is, how about your opinion on Hawaii telecom services? Why telecom services? Hello.
I'm looking at that. I apologize. I'm not familiar with that case.
So you have not read the case. That's fine. Absolutely fine. Now,
I apologize.
Now, last question.
Sure.
Due to this COVID-19 conditions prevailing, frauds are bound to happen. Can you throw some light on healthcare front?
Frauds are bound to happen on the healthcare front.
Healthcare front. Any comments on your personal capacity?
Yeah. So I guess I'd say businesses are under a lot of stress right now, right? With COVID-19, there's right now in the United States, there's record high unemployment. There is Oil right now, you may have seen, is in negative territory. And so when businesses are under such pressure, they may be tempted to do things they normally wouldn't do. And they should resist those temptations because well, for moral reasons, but also because they could really be subject to tremendous liability under the FCPA. As to healthcare frauds in particular, I don't really know or have the expertise regarding that. Hopefully we'll avoid those.
Yeah, exactly. So thank you very much. Thank you, Professor Tom, madam. Thank you very much.
Thank you so much for having me. It was such a pleasure.
Yeah, as I was interacting you before the start of this webinar, one point I must not fail to mention to you, that this type of happening has been started under the guidance of our Chancellor. As I mentioned to you, he said this is the time when we must be nearer to our students, and the best way to be nearer to students is keep them engaged intellectually. So the intellectual engagement is the genesis of the webinar series, and you are the person who we identified that yes, here is a person who came to us, who visited us, who wanted to collaborate with us, and he is going to speak to our students on a very important topic of today. And you did a great deliberation on it. Yes, there are many gray areas. It is difficult to plug the gray areas. That's how the research is on. That's how the different type of legislation it needs to be required to be taken care of. Because we say law follows the society. When the society grows, law essentially needs to be accordingly taken care of. That's how our demand as a researcher still exists. Now, I personally, on behalf of the entire Amity Law School and the Amity University, and on behalf of our founder president, Dr. Ashok K. Chauhan, and our Chancellor, Dr. Atul K. Chauhan, we really appreciate and your contribution to our great endeavors. Now, I request Aditya to say a few words to Tom. Tom, you have become now our great friends. You are friends.
This was such a pleasure, and I'm so honored to be here, or to be virtually with you. I wish I could be in person. I will do it. Thank you again.
Thank you.